If you have kids between the ages of 14 and 22, or if you are within that age range, then you need to pay very close attention. These are the ages that are most at risk of becoming an accidental perpetrator of statutory rape. That's right, accidental. They may not intend to break any laws, but for this particular crime, not knowing someone's actual age is not a defense, even if the other person lied about their age. Statutory rape is what's known as a strict liability crime because it does not require the intent to commit a crime like theft and murder do. In Texas, a child is defined as a person that is under 17 years of age. That means no child is legally capable of consenting to sex because the age of consent in Texas is 17 years of age. Because a child cannot consent to sex, a person, including another child, commits sexual assault of a child by engaging in any sexual contact with the person that is under 17 years of age. However, the most important thing to note is that there does not have to be lack of consent when it comes to children. An offense occurs even if the child is willing, and their willingness to engage in the sexual act is not a defense. Yes, I know that's a disgusting defense when you consider someone older with someone much younger. However, consider it in the context of a couple of 13-year-old kids, where that attempted defense might be a little more plausible. Because of the language of the statutes, there isn't much wiggle room, and there aren't many exceptions that would limit any offense as long as certain factors are met. There are a few affirmative defenses to prosecution that are available. We will be covering the spousal defense and the Romeo and Juliet defense. If the child and the perpetrator were married at the time of the offense, then that may be asserted as an affirmative defense to prosecution for the child's spouse. That is only for the child's spouse, though. Hypothetically, if the child were to commit adultery, then that person would not be able to use the spousal defense. This would be one of the very few times where a homewrecker could actually go to jail. Luckily, our legislature has recognized that kids will be kids and has carved out a defense so that hormone-charged teenagers aren't locked away for years and forced to register as sex offenders because they let their hormones make their decisions. If the child is at least 14 years of age and their partner is not more than 3 years older, then they may be able to assert this affirmative defense. Take note though, I said not more than 3 years and didn't say not more than 3 years and 1 week. Remember, this law is strictly applied, so don't expect any leniency when it comes to calculating that age difference. But age isn't the only consideration for Romeo and Juliet. The actor cannot have been registered as a sex offender or have had a conviction for sexual assault at the time of the offense. Also, the child may not have been someone that the actor would have been prohibited from marrying under the Texas bigamy laws. Finally, the child may not have been someone that the actor would have been prohibited from engaging in sexual contact with due to relationship by blood or marriage. As parents, we recognize that children are prone to have lapses in judgment. This video is a difficult subject for parents to bring up with their children, but we would much rather prepare them for the legal consequences of their actions instead of trying to defend them after the fact. From all of us here at Matthew Harris Law, please be safe and smart about your actions, and please have this conversation with your children.